Losing a loved one is undeniably one of life's most challenging experiences. During a time of profound grief, families often find themselves facing an unexpected burden.
Amidst the emotional toll, there is the sudden, overwhelming stress of legal and financial complexities. Navigating the legalities of an estate can feel like learning a foreign language while trying to heal.
One of the most common and confusing aspects is the probate sale. Our goal today is to provide clear, actionable information for executors and heirs facing this process. Resources like Probate US are here to guide you. Before we dive in, please note this video is for informational purposes only and not legal advice. Please consult with a qualified legal professional for personalized guidance. When a property owner passes away, their assets often need to be sold to settle their estate. This is known as a probate sale, which is simply the court-supervised sale of a deceased person's property. This usually happens for two reasons. Either the deceased person's will specifically directed the sale, or the estate lacks enough cash to pay off outstanding debts and taxes. The key difference here is the heavy involvement of the probate court. Every major step must be approved by a judge. This strict oversight might slow things down, but it plays a crucial role. It protects the estate and its beneficiaries by ensuring the property is sold for a fair market value. Contrast this with a traditional real estate transaction, where buyers and sellers negotiate independently. In a probate sale, buyers must submit formal offers, wait for court confirmation, and may even face a live bidding process in the courtroom. It is a highly regulated environment. When a loved one passes, their estate often includes unresolved financial obligations. A probate sale frequently becomes necessary simply to generate funds. The executor must settle outstanding debts, such as credit card balances, medical bills, and funeral expenses. Additionally, proceeds from the sale might be required to cover hefty federal and state estate taxes. Beyond clearing debts, selling the property is often the most practical way to divide an inheritance among multiple heirs equitably, whether dictated by a will or state law. Finally, managing a physical property can be incredibly overwhelming. A probate sale drastically simplifies asset management for the executor, ensuring the estate is settled responsibly and efficiently. Navigating a probate sale involves a very specific, step-by-step, court-supervised process. To begin, step 1 is the petition for probate. The proposed executor or administrator must file a formal petition with the local probate court to officially open the estate. Step 2 is the appointment of the executor or administrator. Once the petition is reviewed and approved, the court issues documents known as letters testamentary or letters of administration. This provides the formal recognition needed, officially appointing the personal representative and granting them the legal authority to act on behalf of the deceased's estate. Moving to step 3, inventory and appraisal. The executor meticulously catalogs all estate assets. For the property, a court-appointed probate referee typically conducts a formal real estate appraisal to establish its fair market value. Step 4 is the petition for sale. The executor files this document to request explicit court permission to sell the real estate. Once permission is granted, we reach step 5, listing the property. The house goes on the market, ideally represented by a real estate agent who is well-versed and experienced in the nuances of probate transactions. Step 6 is offer and acceptance. Once the property is listed, an initial offer is received and accepted by the executor. Step 7 requires a notice of hearing. The executor must inform all heirs, beneficiaries, and interested parties of the proposed sale terms and the upcoming court date. Step 8 is the confirmation hearing itself. Here, the court formally reviews the proposed sale, checking that the property was properly marketed and the accepted price is fair and aligns with the initial appraisal. Step 9 is the exciting overbidding process. Even with an accepted initial offer, other interested buyers can attend the confirmation hearing to submit higher bids. This acts much like a public auction right in the courtroom. Step 10 is court confirmation. Once the highest bid is determined, the judge strikes the gavel and issues an order confirming sale. Finally, step 11 is the closing. The parties meet at the closing table, signing final documents like the deed and closing statement, funds are transferred, and the probate sale is successfully finalized. Even after an offer is accepted, a probate sale isn't necessarily final. The court's main goal is to secure the absolute highest price for the estate, which opens the floor to the overbidding process. At the court confirmation hearing, new buyers can step in and outbid the original offer. There are strict minimum overbid formulas required by law, and anyone can participate as long as they arrive with a cashier's check for the deposit. Ultimately, the judge holds full discretion to approve the winning bid. So, what does the timeline look like? Filing the initial probate petition takes 1 to 3 months. Listing the property and securing an acceptable offer takes 1 to 2 months. Waiting for court confirmation adds another 1 to 2 months, followed by a standard 30 to 60-day closing period. While every estate situation varies, executors and heirs should prepare for the entire journey to take anywhere from 3 to 8 months from start to finish.
When navigating a probate sale, the expenses extend beyond traditional real estate commissions. You need to account for specific legal and administrative costs. These include professional appraisal fees, attorney fees, court filing fees, bond premiums, and the ongoing costs of maintaining the property while it sits vacant. Always consult with a qualified probate attorney or real estate professional to get an accurate estimate of these costs up front.
As the executor or administrator, you carry a strict fiduciary duty. This means you are legally obligated to act in the best interest of the estate. Your core responsibilities include securing and managing the physical assets, paying off legitimate debts and taxes, and keeping meticulous records of every financial transaction. Transparency is critical. You must maintain open lines of communication with all beneficiaries, keeping them informed of the sale's progress. Above all, you must strictly follow every court order issued by the probate judge. Deviation from these directives can lead to personal liability, so proceed with diligence and care. Navigating a probate sale successfully requires assembling the right team. Start by hiring an experienced probate attorney and a real estate agent who specializes in these complex transactions. They will guide you in pricing the property accurately based on a professional appraisal and preparing for potential overbidding in court. It is also crucial to diligently maintain the property throughout the process. Be completely transparent with buyers regarding any known defects and maintain open, effective communication with all heirs involved. However, there are common pitfalls that can easily derail the process. Avoid neglecting a proper appraisal, which can lead to mispricing. Never fail to disclose property defects, as transparency is legally required. Be vigilant about court deadlines, because ignoring them will cause significant delays. Poor communication can lead to disputes among heirs. Most importantly, avoid illegal self-dealing, where an executor acts in their own interest rather than the estate's. A misstep here can lead to severe legal consequences. While a probate sale is common, it is not the only option. Depending on the estate, you might consider alternatives like a distribution in kind, where the property is transferred directly to the heirs. Other options include taking out a mortgage on the property to pay off estate debts, using liquid assets from elsewhere in the estate, or exploring summary probate proceedings if the estate is small enough to qualify. Navigating a probate sale can feel overwhelming, but remember that you do not have to do it alone. With the right team in place, including a qualified probate attorney and an experienced real estate agent, this complex process can be managed smoothly and effectively. To help you get started, visit probateus.com to find local probate courts and valuable resources in your specific county. Take a deep breath, seek professional guidance, and move forward with confidence. Thank you so much for watching. We hope this guide has shown that understanding the probate sale process can truly empower executors and heirs during what is often a very difficult time. If you found this video helpful, please give it a thumbs up, subscribe to our channel for more valuable content, and drop any questions you have in the comments section below. For more detailed information and to find your local probate court resources, be sure to visit probateus.com. See you in the next video.